Welcome once again to Lehto's Law. Here's Steve Lehto.
Had a whole bunch of people send me this story, and it's been widely reported, but a man was served a cleaning liquid at Cracker Barrel. Now the restaurant has to pay him millions of dollars. And several different headlines pop up if you type in Cracker Barrel and this story, and a bunch of them said he was served a chemical. He was served a chemical. And chemicals can be all kinds of things. It's not actually that useful, but it was a cleaning liquid. So a man was served a cleaning liquid at Cracker Barrel. Now the restaurant has to pay millions of dollars. Marina Potofsky wrote this for USA Today, but widely reported. Cracker Barrel has been ordered by a court to pay over $9 million to a customer after the restaurant served him a glass of water mixed with a cleaning chemical. The customer had lunch at the Cracker Barrel location in Marion County, Tennessee, back in 2014, according to court documents and a statement from his attorneys. Marion County is located approximately 30 miles west of Chattanooga, Tennessee. During the incident, the man took a sip of what he thought was water and then experienced a burning feeling in his mouth and esophagus. He then went to a nearby emergency room where he developed gastrointestinal issues, including cramping, reflux, pain, and more, according to his attorneys. The chemical was apparently something called Ecosan, which is a food contact surface sanitizer and destainer for use in low temperature ware washing machines, according to the website for Ecolab that makes Ecosan. So it's designed to clean and remove stains, not to be ingested. A Tennessee jury earlier this month awarded the man more than $4.3 million in compensatory damages and $5 million in punitive damages, but he will not get that money because Tennessee has a cap on damages, a state law. The court's judgment on the jury's verdict states that the man is to be awarded $4.4 million. So apparently he gets the $4.3 million compensatory plus another $0.1 for punies or something there like that. While we have great respect for the legal process, we are obviously disappointed by and strongly disagree with the jury's award in this case. Statement from Cracker Barrel. Although we are considering our options with respect to this verdict, we are glad this matter is behind us so we can better focus on caring for our guests and employees around the country, the statement said. Presumably, they're going to try to figure out some way to not be serving people cleaning fluid instead of water. The statement from the man's attorneys alleged that Cracker Barrel servers regularly used unmarked water pitchers to mix the Ecosan and water together and then soaked parts of the soda machine in that mixture in order to clean them. And that, they think, could cause the confusion. We are very happy that the jury found for our client. He's a good, honest person, and he must live with the fallout of Cracker Barrel's dangerous policy for the rest of his life. That's the attorney's statement. They argued that the injuries were severe and persistent enough that he could not work. I read in another version of this story that the jury returned very quickly with both the actual damages and the punitive damages award. And it sounds like such a simple thing. You know, you walk into a restaurant, you sit down, and there's water that gets put on the table, and you go to drink the water, and all of a sudden you realize it ain't water. It's burning, and you have to go to the hospital. And it sounds like these are permanent kinds of injuries to your mouth and esophagus or throat. And this is the kind of thing where I think a lot of people are going to go, $4 million for that? Well, it depends on how severe those injuries are. Because think about the last time you had a sore throat, for instance. Just a sore throat. And every time you swallow, it hurts. Okay? And I've had sore throats before where I only have them for a couple days. But by the end of the second or third day, I'm on the verge of going ballistic because of how much pain I'm in from swallowing. And imagine if you had that kind of pain every single day for the rest of your life. I'm just giving an example here, okay? So I wasn't at the trial. I doubt that you were either. And so people are going to ask, you get $4.5 million for something, all you do is take a swig of something. Well, that's the thing, is that it's hard for you to imagine that because it hasn't happened to you. One thing I can tell you about most of the cases involving personal injury, where somebody hurts their back and they sue and they get a bunch of money, or they're in a car accident, they break their leg and they get a bunch of money. or they're in some other weird freakish accident. Piano falls from a 27th floor and crushes somebody, but they live. That kind of thing. Most stories I've heard where somebody got some huge amount of money, if you looked at the injuries they had and then asked yourself, would you take those injuries for that money? Most people go, no, I wouldn't do it. And that's the weird problem that happens with personal injury cases. Because personal injury attorneys, both plaintiffs' attorneys and defense attorneys, will tell you that they can actually guess what juries are going to do. For instance, if you've got a healthy young man in his 20s who gets a broken leg, what's a broken leg worth for a young man in his 20s in this jurisdiction? For instance, right? And I know attorneys who can tell you, and all day long, they're very, very close to predicting what a jury would do on that. But that's not quite the same as the mental calculus that goes into determining those damages. Just because you can predict them doesn't mean you understand them. And follow me on this one. Because what these attorneys have done is simply watched enough juries over the years to figure out what juries are going to do. But in reality, what a jury's got to do is ask the question, what is that worth? Because we can't order the defendant to heal that person, because that's not how this works in real life. All we can do is order the defendant to cut a check. And some things don't have price tags on them. Right? So, how much is your right arm worth? So, you're the juror on a case, among other jurors, and you're hearing a case where a guy lost his arm. Just picking something random here. Guy lost his arm. What's your arm worth? And you might say, well, but we can come up with a number. You throw a number at it. Ask yourself, if someone walked up to you on the street, arm's length transaction, excuse the pun, and said, tomorrow you're going to wake up missing your arm. What number do I write in this check to make that okay? Most people say, no number you write in the check's going to be okay. None. I wouldn't willingly enter that transaction. So that's why it is so difficult for us to comprehend these stories. Now, this is a little unusual because it's kind of hard to understand when it simply says you develop the gastrointestinal issues, cramping, reflux, pain, and more, but he's still experiencing this years later. And presumably he's experienced it every single day since then, and he's going to experience it every single day going forward to some extent. What's that worth? If someone walks up to you and says, I want to cut you a check, you're going to go through that for the rest of your life. I'm going to cut you a check. How much? Most people say, I don't want the check. I don't want the check. So it's kind of hard for us to wrap our heads around it. But keep in mind that Tennessee apparently has had some kind of reform where they put caps on damages. And I'm wondering if it's a cap on actual damages or just punitive damages, because the 4.4 does come out to be 4.3 in compensatory plus 100 in punitive damages, or I don't know. It could be something else as well. But I saw several references to there being caps on various types of damages in Tennessee, and that knocked the award down. Now, obviously, Cracker Barrel can appeal this, and if they take this on appeal, one of the things that will happen is the other side's going to go, oh, well, while we're up on appeal, we may as well ask, can we have some of that money back that got taken away from us under that cap? That's a possibility. But then the question is, if it goes up on appeal, how long does that take? And then if one side loses or wins that appeal, they take that to Tennessee Supreme Court, all kinds of stuff. So this probably isn't the end of it, but it's a wild story. So a man was served cleaning liquid at Cracker Barrel. Now the restaurant has to pay him $4.5 million. Marina Petovsky wrote this for USA Today. And the story is sent to me by Derek, River, Brandon, Tequila, Derek, Chad. By the way, Derek, two different spellings, D-E-R-E-K and D-A-R-I-C-K. Chad, Ben, Trocon, Keith, Daniel, and Scott. Thanks, everybody. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Just do once what others say you can't do, and you will never pay attention to their limitations again.